Good afternoon all. I'm very happy to begin this discussion. The discussion starts from the book by Neera Chandhoke, Contested Secessions, Right, Democracy, Self-Determination and Kashmir. It's a very important new book. We published an issue of our journal, Philosophy and Public Issue, which discusses this book. Among other discussants, there are here, from my left, Neera Chandhoke, the author of the book, Margaret and Buchanan. But before doing that, I want to thank you, Gianfranco Pellegrino and Michele Bocchioli, because they made a great job with the journal. We have got the journal, it's rather efficient and for the Italian standards, rather extraordinary. And now to present a little bit our cost, because before we begin, I say that Neera Chandhoke, professor of political science at the university, is an old friend of us, if she permits, has been visiting very often this university, and we have an enduring dialogue, which we never agree, but on the fact that we agree. We never agree on the subject, but we agree on personal principles. I mean, she is the author not only of this book, but of many other books, among which has been very renowned beyond secularism and the conceit of civil society. Margaret Moore instead comes from Canada, Queen's University. She wrote a book on foundational liberalism, and another one that I wrote on the ethics of nationalism, and it's now work on territorial rights, and is one of the main authors in this area. Alan Buchanan, to my right, it's easy to distinguish, is the only one man here except me. He's professor of political philosophy at Duke University. His main fields of interest are justice, gene ethics, and the morality of international law. He's an author of many, many books and an infinite number of very prestigious papers. One of the leading world political philosophers. I mean, it's also the prominent author in the topic we discussed today, namely Secession. His work of 1991, Secession, has been translated in many languages, including Italian, and there is the starting point, all discussion in political theory on this subject. He's also the author of many other books, Accession, among which Beyond Humanity, which treats genetics, and Justice, Legitimacy, and Self-Determination on the Morality of International Law, which is a very important foundational book on this topic. And finally, thank you very much, Valentina Gentile, for organizing all that, not only this afternoon, but the idea of discussing secession. And the book by Neera, it's a book about contested secession. I mean, I think that one of the most important things within the book is to compare liberal theories of secession with the post-colonial world. The different interpretation we can give of secession due to the specific location of them. I mean, this is, of course, not done from a geographic point of view, but from a political theoretical point of view, so that the contested concepts are not only the one of secession, but also the ones of democracy, self-determination, even nation. And of course, alternatives to secession are examined, like minority rights and relative autonomy. But I don't want to speak about the book, because our guest will do it in a much more correct way. So I just begin by, in which order are we supposed to? Before the author, so we have before the author that will present with the book, and then the others will discuss it. I excuse myself because I leave the chairman position to Gianfranco Pellegrino, because when I'm in LUISS, unfortunately I work, I cannot get all what you are going to say, but in a few minutes we'll be back. Thank you very much for being here all. And our guest, we will have a second part of discussion with, among others, Daniela Chandhoke, Giancarlo Cosetti, and Valentina Gentile will coordinate it.
Thank you. I made my first presentation on what is going to be a book called Contested Secession here at LUISS in 2009. So I'm extremely grateful to Sebastiano, to Gianfranco, to Michele, and to Valentina for organizing this, the first one, as well as this, which has seen a book from germinating from an idea into getting feedback on what I have to say. It was the course of fieldwork in Kashmir for another project I was on. Is it all right? Yes. It struck me how little actually we in India have thought about the Kashmir issue. The issue is so polarized that Kashmir is such a divisive kind of an issue. So on the one hand you have unflinching votaries of self-determination saying that Kashmir should be given self-determination. You have Arundhati Roy, very famous novelist, getting onto the same platform as Mr. Gilani, a patriarch of the separatists who kind of insists that Hindus and Muslims cannot live together in India and we need our own state, irrespective of the fact that the two-nation theory has been disproved by now. On the other hand, you have hardcore security experts, expert geostrategists, international relation theorists, and of course South Asian area specialists who talk about Kashmir as if it was a people and a territory which needed to be tamed. And it struck me that in these polarized positions, the real issues at stake were being obfuscated. And the real issue is simply this: when does a territory which is a part of a democratic country have the right to become an independent country? And when, in what circumstances, is it justified? It follows that secession is not a primary right. There are a clutch of philosophers who think it's a primary right. People should have the right to decide which state they live in. But I basically think this is, you can't put this at par with the basic right to freedom or the right to equality or the right to justice. The second issue is very simple. Even if we can make out a case for secession, is it politically wise? Is it politically prudent? And I'm talking about prudence the way Aristotle uses it as a faculty of practical reasoning. Is it politically prudent? If we look at the map of the world at the end of the Cold War, we see a rash of new states being formed. The United Nations has been very careful not to use the term secession. Even in Yugoslavia and Czechoslovakia, the United Nations did not use it, these new states that emerged, as a case of secession, but as a case of federalism that has failed, or as a case of a country that has failed. The only successful case of secession, this is I'm sitting next to two political philosophers who have written much before me and extensively, and I've learned a great deal from both of them, that the only successful case of secession was Bangladesh, in the sense that United Nations recognized Bangladesh 3 years after Bangladesh had declared itself independent. But it recognized Bangladesh only after Pakistan recognized Bangladesh. And Pakistan recognized Bangladesh because the Association of Oil-Producing Countries forced it to recognize Bangladesh. So there is a certain logic which actually defies logical thinking when it comes to the rules of international war. As Tesson points out, that the rules of international law are the rules of war, because a secession succeeds or it doesn't succeed. Kosovo has succeeded insofar as individual countries have recognized it, the UN has not. So you have states, which are there, which individual countries have established bilateral relationships. Very, very powerful Western countries have recognized Kosovo. But they have not recognized Northern Republic of Somaliland. They have not recognized Western Sahara. Certainly they don't recognize the right of the Palestinian people to their own state. These are the rules of war, because so what are these states? Are these states, or are they proto-states, or are they de facto states? Well, what are they? They're floating around in a twilight zone. But the second issue, which I think is of interest to political theorists, is not whether a secession is successful or not successful. It is, why do people want to secede from a democracy? And India is a democracy. We're just having the 6th phase of a large election process, currently in the middle of all this turmoil. Why does a territory want to secede? And you look at Kashmir, and I thought Kashmir is a very good test case for looking at a case for seceding from a democratic country. Briefly put, the accession of Kashmir, which was outside British colonial India at independence, that is 1947, was through accession on very special terms, which were later ratified in the Constitution and through what came to be known as the 1952 Pact with the government of Kashmir. And it was entitled to considerable regional autonomy. In fact, Jammu and Kashmir is the one state that is in the Indian federal system, has a very unique special status. And after 1953, the status began to be eroded by the government of India. Now this, I think, is a case of institutionalized injustice. When you have a contract with a territory and with its people, you do not break that contract. It came to India on special conditions. Those conditions should have been honored. There is no other way to justice. The second reason why I think there has been institutionalized injustice as far as the people of Kashmir are concerned is willful violation of every civil liberty that the Kashmiris possess. In that case, there is discrimination because they are subjected to laws which the rest of India is not. The Armed Forces Special Powers Act, which exempts army officers from whatever act they commit, whether it's rape or whether it's murder or whether it's burning of entire villages. Looked at that, in that case, and secession, it follows, is a right that can be justified only in cases of veiling of justice, violation of other moral rights. It is, Buchanan puts it as a remedial right. I use the terminology contingent right, but basically I think the argument runs along Buchanan's own argument. Having said that, a right is not just a right. A right has to be measured against countervailing considerations. Even the right to freedom of expression, all of us know, is not a complete right. It has to be weighed, particularly a right like secession. And it seems to me that there are three, and I'll wind up after this particular point, there are three sets of immediate considerations and one set which is long-term, which weigh against this right being a complete right. It is a weak right in a democracy because possibly the government will revert and restore justice. But it's rendered still weaker by the following considerations. First of all is the acute minority problem. The minority problem is something that bothers every philosopher of secession. But the Jammu and Kashmir, we see a very special case because every minority has now mobilized and said we don't want to go with the valley because the valley is the hub of where the secessionist demand has come up. Kashmir was a very hastily patchwork state which the British East India Company sold to a Hindu king for a sum, a very paltry sum. It is multilingual, it is multi-religious. So the Buddhists of Buddhists of Ladakh don't want to go along. The Shias of Kargil don't want to go along. The very, very communalized Hindus of Jammu don't want. And every hill tribe now says, we want closer integration with India. Now, how do you reconcile the problem of competing rights? So the demand for secession has come, and it has come for very good reason because of institutionalized injustice. The people of Jammu and Kashmir suffered this injustice for as long as 40 years before they erupted in 1990. There were 1 million people marching in sleet and snow, covered in white shrouds to the headquarters of the UN Military Observer and saying Azadi. Junaid Irriani will tell us what Azadi means. Azadi is a tricky term in Urdu. It can mean anything from autonomy to independence. So that's the problem for people who try to work on Kashmir. What exactly do you guys want? At that point, the Indian government was completely shaken up because they didn't even remember that Kashmir was contested by many. The plebiscite had not been held. There were reasons behind it. The UN had laid down certain conditions. The conditions were not met. People had been deprived and the democratic space had closed off. Many of these leaders who now lead a talk of separation were leaders who wanted to be a part of the system. They were prevented from doing so by the regional party, not only by the central government in cahoots with each other. So what do you do with the minority issue? I'll come back to it in the very closing last minute. The second issue that bothers one is, the valley arose in anger, in frustration, in sheer rage. And the Kashmiris, by and large, are a very soft people. They are marked by a very soft Sufi Islam. That anger should have sent warning bells rung warning bells in the ears of the policy-making establishment, but it did. Within 4 years, you find a whole group of outsiders coming into the valley with Afghanistan problem coming up. It's not an issue of Pakistan creating a problem in Kashmir. Mercenaries from that part, Pakistan, Afghanistan, could only play upon discontent once it had been created. You can't play upon discontent in areas where there is no discontent. Now, when the mercenaries hijacked the movement, they completely transformed the terms of debate. And now it's no longer about justice, or it's about erosion of democratic rights, or about regional autonomy. It's about jihad. This raises a problem for many of us as concerned citizens, as scholars. Why would we back a group that says two nations cannot live together? So the hijacking is a big problem. The third is extreme amount of violence. We have spoken, our team spoke to a number of separatist leadership. They have no idea what they want to do with independent Kashmir. I often saw somebody, I said, do you think of minority rights of minority? That's a fad, it's like NGOs. Of course not, we're going to be an Islamic state. Now, there is a problem, how can you, it's like the Canadian Supreme Court saying, you negotiate, and negotiate within conditions. Those conditions are not going to be filled because somebody will probably pick up an AK-47. So these are the three, I'm finishing, the three considerations that inhibit an outright defense of the right to secede. The fourth is simply this. What is the kind of context that people should live in to actually realize themselves? Is it monocultural, monochromatic communities, or would it be plural communities? We have seen the problem with monochromatic states. We have seen the problem, but in a plural society which facilitates dialogue and toleration, there might be a case for saying maybe the time for the nation state is over, because the nation state has done nothing but replicate the problems of the earlier nation states. South Asia, we are very, very conscious of this problem. The number of people that were killed in Sri Lanka to keep a united Sri Lanka. Thousands of Tamilians have been killed. It's now coming up. It's now coming up in the form of sanctions. It's happened in all parts of South Asia where very plural, loosely articulated societies have tried to build nation states. Isn't it better that people live in an environment where they learn the art of compromise, the art of dialogue, the art of deliberation? If that is so, should not self-determination be detached from secession and made a constitutive part of democracy? Thank you.
Okay, thank you, Neera. And then we will have our comments, same order on the journal. So Alan Buchanan first.
Thank you. I'm very happy to be here. Thanks for inviting me. This is an excellent book. It's a genuine contribution to the literature on secession, and I especially commend it because it's unusually rich in its detail regarding the facts of contested secessions in the post-colonial context in particular, and especially the case of Kashmir. I had been reading about Kashmir for many years. I found it very confusing, and when I read Neera's book, it became much clearer. I saw the patterns much more clearly. It made a lot more sense, and it was easier for me to think about what the normative issues were, because I think I had a better understanding of the facts thanks to her. I also profited from her analysis, not just her descriptive characterization. She raises a really interesting question by focusing first on contested secessions. That's the more general topic, and then the more specific one is contested secessions in the post-colonial context. And I agree with her entirely that this context has been neglected in literature on secession. I think that she asks a good question when she tries to identify what's distinctive, if anything, about contested secessions in the post-colonial context. I'm not convinced that she succeeded in showing that the features that she identifies are limited to the post-colonial contested secession context. But in some ways, I don't think that's so important. They're certainly very prominent in those cases. And in a way, I think it makes her analysis more valuable if she's incorrect in thinking that they're unique to these cases, because her analysis may have more generality than she thinks if I'm correct in thinking that the features she identifies as being unique to the post-colonial case actually are a considerably wider application. As I understand her, the three features that she thinks are distinctive of the post-colonial context of contested secession are, first, that the secessionists are using or are ready to use premature and or excessive force. Second, that the new state they hope to create will not be liberal. And this is very important because often when philosophers talk about secession, they assume a sort of best case scenario, at least from their standpoint. Most of them are writing from a liberal perspective. And so they tend to think that after secession, things will be the way they ought to be. There'll be a liberal society. And then the third feature is that the state from which the group wants to secede is not fully democratic. Now, I think that all of those characteristics play an important role in the dynamics of a contested secession, but I think they're pretty widely applicable. I think, in fact, they apply to most contested secessions. For example, the American Southern Secession in 1861, the secessions from Yugoslavia, the Kosovo independence from Serbia. I think they're a wide application, but they're extremely important. And the question is, how should an awareness of those factors shape our thinking about secession? She also makes a distinctive claim, and I'm a little unclear about how to formulate this exactly. I may not have understood her properly. She could correct me. At some points, Neera seems to say that when the state from which a group wants to secede is a formal democracy, then there is no unilateral right to secede. That is, if secession is to occur, it has to occur through mutual consent and negotiation. There's no unilateral right. At other times, she seems to say something very close to that, but a little different, namely, when the state is a formal democracy, then perhaps there is still a unilateral right to secede, but it's weaker. It's somehow, the claim involved is somehow weaker, more easily overridden. So I'm not sure exactly how to interpret it, but either way, it seems to me that it's counterintuitive to say that when a group wants to secede from a state that's formally democratic, that means that their claim is very weak or weakened very much, because it might be, you can consider a case where a certain territory has been unjustly annexed by a country, and at the time of annexation, perhaps it wasn't democratic, perhaps it was democratic. Sometimes democratic states do engage in unjust, aggressive annexations of territory. They haven't done so in recent times, but you could have a situation where one state unjustly annexes a piece of territory from another state, incorporates it, it becomes part of that state. Then the state becomes a democracy. But the fact that it's a formal democracy doesn't in any way weaken the claim of the people in the area that was unjustly annexed for remedying that injustice of being unjustly annexed. So it seems to me they could have, under some circumstances, a unilateral right to secede from a formal democracy. But suppose it wasn't a case like that. Suppose there was no unjust annexation of the territory that now wants to secede. Sometimes democratic states, even states that are a little more than formally democratic, can just be unreasonably rigid in refusing to consider the possibility of some region within that state either becoming more autonomous, having some significant form of limited self-government, or seceding and becoming independent. Think of the case of Spain. Spain steadfastly refuses to negotiate with the people of Catalonia either about greater autonomy for Catalonia within Spain or about independence from Spain. And I think that one of the things that's feeding the Catalan secessionist movement at this moment is this rigidity on the part of Spain. In the past, Catalonia has enjoyed some autonomy, some limited self-government, but some important aspects of it, especially with respect to language laws, have been struck down by the Spanish Constitutional Court. And so I think the Catalans quite understandably feel that even though they live in a democracy, that their claims to either greater autonomy within Spain or perhaps even independence are falling on deaf ears. The fact that the country's democratic is not making a difference. They're not having they're not seeing any willingness on the part of Spain to even consider the possibility of a negotiated, mutually agreed on, lawful constitutional process of secession of the sort which may occur in Scotland. The case of the UK's attitude toward Scotland is the mirror image of Spain toward Catalonia. So I think that it's a bit more complicated. Just being a formal democracy, I agree that if you have a democracy, even if it's an imperfect democracy, it's only formal, then at least a group that is contemplating secession has a moral obligation to try to negotiate, to try to use peaceful means to gain either greater autonomy or secession. But I think a limit can come to that if their efforts are completely ignored, as they have been by Spain, for example. Then at that point, the fact that it's a formal democracy is not something that outweighs a legitimate claim either to autonomy or to secession. So I have a sort of qualified acceptance for that claim that Neera makes. Now, let me mention one other thing. Neera looks at the case of secession, as far as I can tell, strictly as a two-party case. That is, we only look at the secessionists of the state from which they're trying to secede. And that's the way I looked at it in my book on secession a long time ago, 1991. Since then, I've been exploring the possibility of thinking about it not just as a matter of concern for the two parties, but a matter of concern either for the region in which the state exists or even for the whole international community. And because often if a secession occurs, it has effects on others, not just on the two parties involved, not just on the secessionists and the state from which they're seceding. And I also think that it's worth thinking about the possibility that there could be some role for third-party mediation of self-determination conflicts. Let's call them self-determination conflicts to cover both the case where a group wants greater autonomy within the state and the case where they want full independence. The difficulty is that there's what you might call a two-sided assurance problem. In some of these cases, autonomy rather than complete independence would actually be the best outcome for both parties. But it's very hard to broker a sustainable autonomy agreement because on the one hand, the state may fear that if they grant autonomy to the group, that'll just be the beginning of a slippery slope toward demands for full independence. So they're reluctant to grant autonomy. And they're worried that if they do grant autonomy, the people in that region may abuse the autonomy agreement. This actually is what the Serbs said about the Kosovar Albanians. They claimed that they were revoking the autonomy status of Kosovo because the Kosovars had abused the autonomy status. Saddam Hussein in 1974 revoked the autonomy status for the Kurds in the north and gave the same kind of reason. So states, it's not hard to understand, have a fear that if they grant autonomy to a region, it'll be the first step toward a drive for complete independence, or that the autonomy may be abused. On the other side, the group that's seeking more self-determination may be reluctant to commit themselves just to autonomy within the state and completely take secession off the table because they fear that even if the state agrees to an autonomy arrangement, the state can unilaterally revoke it at any time. And this has happened in many cases. Now, when you have that kind of situation, you have a failure of trust on both sides for very good reasons. It's worth considering whether bringing a third party onto the scene might help solve both of the assurance problems. It might be useful to have some third party help broker the autonomy agreement, the presumption being that we should first try autonomy, and that secession is quite a radical and dangerous move, should only be a last resort. So there might be some room for a third party helping to negotiate an autonomy arrangement, and then to monitor compliance with the terms of the arrangement in order to supply assurance to both sides, and to help support the arrangement, to help it work. Okay? This, I think, is an idea worth considering, and it's interesting, again, I keep mentioning Catalonia. The Catalans are trying to get the Council of Europe to do this, basically. They're trying to enlist the support of the European Union, probably through that institution, to support them in their effort now to become independent from Spain. There are good reasons why the European Union doesn't want to do this, because if they do it for Catalonia, they're going to be asked to do it for other groups. So it might be better, if you're thinking about the possibility of a third party who might play this mediating role, to broker an agreement, help monitor compliance with it, help support the agreement, see that it works, provide assurance to both sides. It might be better to think about a kind of ad hoc third party group that would be composed of some credible international figures, rather than a standing important institution which would then be asked by other groups to do this. But I think that's worth thinking about. Now, I think in the case of Kashmir, it's very difficult to imagine how third-party mediation or support might work. I think things have gone so far there that it's extremely difficult, and in some ways it would be hard to find a credibly neutral third party to play this role. But it might be possible in some other contested cases of secession. So I would just suggest that for our discussion and for Neera's further thinking on this topic, that we might want to consider secession not just as a two-party problem, but clearly in some cases one which involves the interests of other parties, and in which other parties might be able to play some role to prevent this kind of characteristic spiral toward violence, where you first have a group demanding autonomy, either the state refuses to grant the autonomy or grants it to them and then unilaterally revokes it, and then the autonomists become radicalized and become secessionists. States typically react very violently against secession, and then you get this spiral of violence. So it might be possible to reduce the risk of that spiral of violence if somebody in the international community were willing to intervene earlier. I don't mean military intervention to broker an autonomy agreement. In general, the international legal system has been unwilling to do this. It's a very statist, very sovereigntist Iranian system, and basically it steps back and allows things to degenerate into horrific violence before it does anything, if it does anything then. Thank you.
Thank you very much, Alan. You even save time. So, okay. So next comment is from Margaret. Please.
So first I'd like to thank the organizers, especially Valentina, for all the work in Franco, and say a few things about Neera's book. So I like this book very much, and it's the kind of political philosophy that I understand, because it's a mix of normative principles tempered by an understanding of how those principles operate in the world in which we live. But since it's rather boring to speak about aspects of the book with which we agree, right? I'll focus on two problems with the book. And the first is that I think this case in particular would have benefited from a more foundational argument about territory and territorial rights, which are directly raised by the case of And the second kind of comment I make in the piece is that the argument I thought runs into more trouble where she departs from Buchanan's original just cause understanding of secession and focuses on democracy as a foundational principle by which legitimate political orders are measured. And I think I'll talk more about territory because some of the comments about democracy have already been made. So I'll talk about territory a little bit and what I think the theory about territory is behind the book. So the book's about secession and it's not about territory, but I have this sense that we could have benefited, or that we would benefit from understanding a number of different sort of events by looking at what the foundational argument about territory is, right? Who has rights over territory, how those rights, what the rights of the territory involve, how we justify them, and so on. And I know that so I think that the case of secession raises it, in the case of Kashmir in particular. And I'm aware that this is, there's always a risk here of thinking that other people should be interested in the same thing that I'm interested in, which is, and then criticizing people for what they don't say rather than what they do say. And I'm going to run into both those risks, but I'm going to try to show that I think that it would have benefited from talking about territory. So I'll just say a little bit about territory first, and then where it was a puzzle in this book. Okay, so when we think about, so the literature on territory, which isn't really, which is kind of, you can investigate it underneath the book. Usually, arguments about theories of territory involve a triangular relationship between three things, right? There's a piece of land, there's a group of people who are resident on the land, and then there's the state, a set of political institutions that govern the people within that geographical domain. And there's different theories about territory, and they all involve different relations between those three things. So whatever configuration you have, you get a different theory about territory. So there's different possible relationships between people, the land, and the state. And the main question raised in Kashmir is who ought to hold territorial rights? What kind of entity should have jurisdictional rights over territory? And this question is raised at a very specific level because there are a number of possibilities. Because Kashmir is divided between India and Pakistan, and there's also a small, relatively unpopulated part in China, which she brackets and I'm going to bracket. And this means that we first have to consider generally whether Kashmir should remain divided or unified, and in the latter case, whether it should be part of India, part of Pakistan, or independent. And the answer to these questions depends, at least in part, on more general understandings of what kind of entity ought to hold territorial rights and the relationship of that entity to the people living there. So, so there are two dominant positions on territory, and they don't exactly correspond to Alan Buchanan's original analysis of just cause and choice theory, around which Chandhoke frames her discussion. But on one understanding, the appropriate or legitimate holder of territorial rights is it's either a state or it's a legitimate state, right, or like a just state. And the general assumption of traditional international relations theory and international law is just that territory is an indispensable component of a sovereign state. It's definitional of a state that it has control over territory. So whatever justifies states will justify territory. So you don't need a special argument about territory. You just need an argument to justify the state, and then like the argument for territory falls out. And the problem with this a little bit, this way of thinking about the argument, is it doesn't tell you which bits of territory. It's an argument that justifies authority over persons and then assumes that it gets you authority over land. Now, whether you think that's true or not, so some people think, well, actually we need an independent argument to justify authority over the territory too. And the reason why this raises a question is there's a long discussion in this book about the history of the Kashmir problem and interpretation of it, and what view we take about who holds rights to territory will make a difference to whether we think that what happened in 1947 was legitimate, and implications too for whether, since it happened, India now has legitimate territorial rights in Indian Kashmir. So just to really quickly say a kind of a problem with some of the just straight statist arguments is that if you just think that you have a state, and if a state's effective, that it gets territorial rights, it's subject to a number of puzzles, right? And so one puzzle is, it's not clear how a moral right can be conclusively justified by purely empirical considerations, such as the fact that an entity has de facto control and can fill the functions of a state. Another problem is, it makes territorial right purely retrospective. It's conferred on whatever entity can exercise power over the domain and fulfill state functions, but it has a problem deciding when there are two aspirant groups claiming territorial rights over the same geographical area. And third, and most significantly, it ignores the interests of the people who live on the territory. So the arguments about the state and the territory, and we often think of those people in my triangular relationship as crucial. Now, of course, lots of normative political theorists don't just have a statist, a crude statist view. They argue that we should only grant it's not that we should grant moral rights to powerful agents regardless of how they treat citizens. So they bring the people in by saying, well, there has to be the right relationship between the state and the people. That is, the state has to be a just state. And that gets you a really nice Kantian view. I take it, actually, that's Buchanan's view, though I may be wrong. But that seems to be at the center of a just cause analysis, right? That the state's justified because it implements justice in its domain. And this, I think, is drawn on by Neera Chandhoke too. So, and this account accords better with our sense of the basis of state authority, and it's invoked by Neera Chandhoke, which she talks about standards of justice and democracy to assess the position of India in relation to India and Kashmir. And actually, one of the really interesting parts of this book is, this is a bit of an aside, but she applies these standards both to the state of India as a whole and to Kashmir specifically. And I take it that the suggestion is that the Indian state is sufficiently just and democratic to claim authority, but there are deficiencies in relation to the Indian state's relations to Kashmir in particular. So she moves really helpfully between those two. Okay, but there's a problem with this general picture, right? So this picture of the state as implementing justice and claiming territorial rights is one that I'm attracted to, and Neera Chandhoke doesn't discuss the idea of territory directly, but she seems to invoke some kind of justice-based analysis, because she draws on Alan Buchanan's largely Kantian-inspired theory of secession. But I wasn't clear how this was consistent with her historical story about the founding of Kashmir, and also with her discussion of democracy at the end. So, as Chandhoke relates, and many of you probably know this better than I do, she does, but as Chandhoke relates, when India gained independence, the princely state of Jammu and Kashmir were not part of British India. But the princely kingdom wasn't independent of British sovereignty either, being subject to the doctrine of paramountcy through various treaty and political arrangements in force. So in October 1947, Pakistan backed armed incursions into pro-Pakistan parts of Jammu and Kashmir, which led the prince, who was a Hindu, to request military aid from India, which in turn requested that the state of Jammu and Kashmir accede to India prior to sending troops. And this led to the signing of the instrument of accession on the 26th of October 1947, which was accepted by Lord Mountbatten, the Governor General of India, but in a letter accompanying the instrument of accession, Lord Mountbatten stipulated that the decision of territorial control of the princely state could not simply be decided by the prince and another state, which was India, but must ultimately be decided through a plebiscite. Now I think right here we have different accounts of territory and who want to hold territorial rights. These accounts are directly in play. And there are different accounts of who the territorial right holder is. And it's not clear that on many accounts that either the prince or the state of India had the authority to make the decision that is a transfer of territorial right, a transfer of a right to legislate and to decide the terms and structure of the entity without regard for the aspirations of the people who live there. And I think this is a problem even for those people who invoke justice as legitimating state authority. Because even if we invoke a general justice picture of state legitimacy, it's not clear that either the prince or the British had territorial rights to pass along or to transfer to India in the first place. So there was a transfer of territorial rights, but the entities transferring the territorial rights, we have to ask, at least on the justice picture of who has them, whether they were the right people to transfer rights. Okay, that is to say, I think actually this might be a kind of general problem about how underdeveloped political philosophy is in this area, because if we apply justice, even understood in a relatively relaxed way retrospectively, then all kinds of political entities didn't seem to be entitled to their territory in the first place, right? But I think that, but you could, I think that there's a real problem here about understanding justice as giving rise to territorial rights, because it actually, at the moment at which we have an entity claiming territorial rights, we have no normative theory about why they should have it. In fact, it looks like they shouldn't. Okay, so you could have, there are different accounts, non-states accounts of territorial rights, right? You have cultural nation accounts like Miller, and actually my own sort of non-cultural nation account, non-cultural account, which talks about a politically mobilized community sharing a common political identity and relationship. And it's not the point to sort of discuss these different accounts, but I guess, but I do think that we should consider the possibility that the right to create jurisdictional authority might not just reside in a state, nor even a just state, but ultimately there has to be some account of it, ultimately by the people in some configuration. I mean, the people having some meta-jurisdictional right. And yet this is at the heart of the rival perspectives on the Kashmir question. So these territorial issues aren't discussed directly and are kind of passed over. And yet I think there was a real opportunity to discuss how we haven't solved the question of how we hold territorial rights and how justice, which, I don't want to give up on justice, right, or democracy, but how this fits also with this other idea of people having meta-jurisdictional authority and the idea that the state, it doesn't explain the origins of the state. So at various places, Neera Chandhoke laments the fact that the referendum to decide the future of Kashmir was not held. But this seems to be largely because it was a mechanism of conflict reduction, rather than a fundamental right that the people of Kashmir held. She is clear that many histories dwell, and this is a quote, on the non-holding of the plebiscite as an original sin of the government of India, but she insists the fault lies elsewhere. It's on page 26. And she details the way in which various autonomy and minority protections that were in place were not adhered to in the period immediately following accession, suggesting that the problem was injustice. But actually, it suggests that, but I think that there was an opportunity to discuss the fact that there's an assumption that justice is what will give you territorial right, and we don't understand there's, at the heart of the Kashmir problem is the question of who has rights to exercise jurisdictional control over territory, and this seems to be that, and so the problem here is that it's clear she's opposed to secession, and so it's clear that she must now regard India as the appropriate territorial right holder. Actually, I'm opposed to secession too, like in terms of like how, that it would be, it often gives rise to egregious violence. But it's not clear, so in some sense she regards India now as the appropriate territorial right holder, but it's not clear how this fits entirely with the historical narrative about the development of the Kashmir problem. So, so that's, I guess, one question that's raised in terms of your historical narrative with what happens afterwards, right? So, I don't know how much time I have. I'm going to give 10 minutes. So, and then the second, there's a kind of another aspect to the book, right? So there's, towards the end of the book, there's some substantive recommendations about improving justice and democracy in Kashmir, and these are arguments that seem actually really interesting and absolutely sensible. And so I don't have much to say about that, but I guess one question that's raised is that this, the expansive conception of democracy includes all kinds of things like rights to participation and procedural fairness, address background inequalities, including cultural and linguistic rights. So this very capacious understanding of democracy as also including self-determination. And I agree with most of the suggestions that she makes, but I guess one kind of thought that I had here was that, I don't know, but as an argumentative strategy, you might think that, well, principles of justice are principles, at least to ensure the just distribution of benefits and burdens of cooperation, and then we might think of principles of democracy as principles that about equal political voice in the institutions of governance. And you might think that principles of self-determination are concerned with group or collective identities and the aspiration of people in their collective identities to have control over the collective conditions of their existence. There are three different things. I mean, and we could work out the relationships possibly between these three things, but I was a bit concerned that thinking about all these things as part of democracy, it makes democracy actually very, very attractive, but you might think that you could have, you know, a democratic state that's not just, you could have, or a democratic state that doesn't actually adhere to various kinds of self-determination. So I endorse your view of democracy, but I mean, I just wanted to say that it's pretty capacious, and it might not be helpful for thinking about various ways in which there's different kinds of deficiencies. That's all. Thank you.
Valentina will give another comment. Valentina also guest edited the journal, the issue of the journal, giving a lot of help to the work of the editors. So, Valentina, the floor is yours.
Thank you. Now it's my turn to thank all of you for this for cooperating with me in this journal issue. First of all, I would like to thank Neera for agreeing, commenting on her book on contested secessions, and then obviously I would like to thank Margaret and Alan for agreeing to comment on that with me. Obviously, I would like to thank Gianfranco and Michele for supporting me in this, and all the people at the center for working very hard in all the things we do in our center. So. Also, I should admit that it's very hard to comment on a topic as secession at the same stage with Alan Buchanan and Margaret Moore and Neera Chandhoke. So I will do my best in order to say something, let's say, interesting. At least the presentation is very nice. So I would like to start saying that writing about secession is not an easy task for a political philosopher, and this is true at least for three reasons. First of all, because secession has a double dimension, as Alan was mentioning before, a domestic one and an international one, so it is not clear how claims linked to these two dimensions can be accommodated in one general theory. Second, that most of liberal theories, in particular contractualism, are concerned mainly with social unity and stability of the political authority. So an alleged right to secession would undermine the very basis of the consent on the common justification of the coercive power. And third, that also on the international side, there are a lot of problems in overcoming, and this is, I think, a little bit the point Alan was making before with the double assurance problem and the involvement of the third parties in overcoming statist or nationalist paradigms in order to make more efforts to think about secession in a less statist way, let's say. So, but to talk about secession in India, I think it's even more difficult. First of all, here I was quoting according to Unlawful Activity Prevention Act of enacted by the government in 1967. Any action or intention, including words either spoken or written, that may support a claim of secession in India is punishable with imprisonment. And second, in India there is a big problem with the fact that there are multiple subnational communities that populate the country that should be accommodated through, within a framework, a common and shared political institutional framework. And third, there is a big problem with violence. The situations in many areas of the country easily translate into violent conflicts and ethnic cleansing. So what has been underlined already a lot of times today is that I think the most interesting aspect of this book is that Neera provides an account of secession that is compatible with both liberal theory, but at the same time, the book aims to assess the case of contested secessions that are those cases occurring in post-colonial societies. So, on the one hand, Professor Chandhoke recovers Buchanan remedial right theory. So, for her, a right to secede can be justified only as a way to redress institutionalized injustice, while on the other hand, she tries to make a case which is spatial and which can be compatible with post-colonial secessions. And this case of secession for Neera imply at least three conditions. The first is that there are weak democratic governments that negotiate with secessionist groups which are often illiberal or violent in areas where these groups are mixed to oppressed minorities. And this is exactly the case of Kashmir. Oh, sorry. In this case, the state is a formal democracy, but has subjected the group of people to institutionalized injustice. The secessionist movements are illiberal and their actions very often involve the use of violence, and there is an important presence of other ethno-religious minorities settled in the same part of the territory. So we go to the main claim of Neera's book. I think the most important part of Neera's thesis is implied in chapter 3 of her book, which is related to the notion of pluralism, to her theory of pluralism. And in chapter 3 is actually devoted to an account of the intrinsic value of pluralism. In defending the intrinsic value of communities, she argues that we should move from an empirical or descriptive understanding of pluralism to a normative one. Quite inspired by Berlin's idea of value pluralism, she argues, though pluralism is a value, it is a value with a difference. Like other normative concepts such as equality or freedom or justice, it captures the desiderability of a certain state of affairs. But unlike most other values, pluralism is a precondition for a plurality of values. In this speech, in this talk today, I want to focus on two distinct but related elements of Chandhoke's theory proposal. First of all, I want to to underline what I consider a sort of ideal version of the remedial right on the theory that Neera proposes, and second, on an emphasis on comprehensive pluralist version of liberalism. And then I move to my criticism, let's say, to her theory, which are related to two different problems, the one of unfisability and the second of indeterminacy. Here I just mapped a bit the debate, the liberal debate on secession. I tried to, let's say, summarize it according to two axes, let's say. On the one hand, I considered the link between the political legitimacy and territory. So I tried to articulate the difference between nationalist vis-à-vis statist approaches, and the second, recovering a well-known distinction. The second level, I tried to go to the justification, let's say, of the theory, which is about primary right and just cause theory, which is more related, I think, to the way in which the notion of self-determination is actually involved in these two different paradigms we see before nationalism and statism. So let's say the interconnections between these two distinctions bring to three different, let's say, most popular theories in the liberal literature on secession. On the one hand, we have in the primary right theories, descriptive and nationalist or plebiscitary and associative theories. Obviously, this is a very rough distinction. Obviously, there are interconnections among distinct theories. And then we have the remedial right theory. What is interesting here is that what I find extremely important as a difference between these two approaches is that the remedial right theory, as one proposed by Alan Buchanan, is a sort of non-ideal, or proposes a sort of non-ideal theorizing about international institution and international law. So international law should recognize the remedial right to secede understood as a last resort response to serious injustice, but it should generally encourage alternatives to secession. So non-ideal institutional theory of international law is meant to offer a principled guidance for how to cope with the problem of non-compliance in our real world. While the second theory is more a sort of ideal theorizing. This means that they are concerned with the morality of secession as such and offer an ideal and not necessarily institutional or not always institutional theory that provides a sense of how a theory of secession should look like under conditions of perfect compliance. I think this is a very important point in order to move and to try to understand Neera's project, and in particular this turns out to be very interesting in the case of contested secessions. So I think Neera proposes a peculiar version of remedial right theory, since she moves back from the non-ideal theorizing proposed by Buchanan to a different sort of ideal theorizing. And this ideal theorizing is, in my opinion, based on her account of substantive democracy, which seems to constitute an important part of a comprehensive moral theory of liberalism, one which incorporates a notion of value pluralism, as I was saying at the beginning, at its core. So Neera resists to a right to secession because it would be inconsistent with such an account of value pluralism. She provides an ideal theory of liberal democracy that incorporates a notion of value pluralism. So this sort of theorizing expects the denial, to put it in a very direct way, a denial of a right of secession is or could be shared and endorsed by all citizens, all democratic citizens, that can find other means in order to accommodate pluralism within the national borders. The problem, my objection with this sort of theorizing is that this theory actually does not significantly differ from other liberal theories that set ideal conditions for the justification of principle of justice. However, as we know in real world, not only national minorities or secessionist groups, but also democracies are not perfectly just, as her theory seems to assume. And this is something that obviously Professor Chandhoke is aware of, and this is also part of her criticism to our other liberal theories, in particular plebiscitarian theories. But I think that the kind of proposal she gives doesn't significantly overcome this problem. So, because I say that when real cases of formal, or let's say unjust democracies dealing with both a liberal secessionist group or rather liberal minorities are considered, the theory is in fact not able to offer a clear framework of moral prescription. But this is exactly the case of contested secession, isn't it? So, Chandhoke's very idea to develop a comprehensive, so I go to my second point, which is more related to the very idea of comprehensive pluralism, which is behind your theory. And I think that this is inconsistent with your own value pluralist premises. And this is very clear when we extend the idea of liberal toleration, when you try to extend the idea of liberal toleration to both a liberal secessionist and minority groups. This situation produces, can produce or might produce two different outcomes. The first I call the problem of unfisability, because if we assume that the commitment to value pluralism is dependent on the acceptance of some prior fundamental liberal values, then the theory is unfeasible, since any governmental attempt to address democratically secessionist and minority claims would find a strong resistance of non-liberal groups. But the second problem is even more dangerous, which is the problem of indeterminacy. If we assume that the commitment to value pluralism is independent of liberalism, then the theory is indeterminate in the sense that it is not able to adjudicate disputes among liberal and other, even non-liberal claims. Obviously, Neera is aware of this, so this is why you link very strongly your theory and you make it dependent on liberalism. But the problem is that in order to avoid the problem of indeterminacy, it seems to me that the theory risks to become inconsistently pluralist. So, in my view, I think that the way to overcome this problem is to move back from a comprehensive account of pluralism to a non-comprehensive one. So, and I'm referring here to Rawls' political liberalism, which is compatible with a thin or reasonable form of value pluralism. Accepting this, when we move from an ideal condition to real circumstances of divided society characterized by competing and reasonable claims, the pluralist premises of the theory should be interpreted in a narrow sense so that it becomes possible to select those institutional and widely accepted political principles that actually set the limit of liberal toleration itself. So it's the limit of liberal toleration, not an extension of it. And I wanted to conclude giving a sort of anticipation of the second session we will have on the case of Crimea, and saying that probably also the case of Crimea is a case of contested secession, but this is for the next part. Thank you.
Thanks, Valentina. Now, Neera will have some room to answer to these comments, and then afterwards we will have a session of questions and answers from the audience.
The responses of the three political philosophers, and my response to them has been published in the journal. So I'll just synopsize whatever I had to say. I am indeed gratified that such eminent political philosophers have taken the trouble to engage with the argument in contested secession, and done so in a spirit of friendly criticism. I appreciate deeply each one of these responses. My own rejoinder to the insightful issues that have been raised and to the reservations that have been expressed will in all probability be inadequate. This is perhaps a given. Few authors can claim that they have said whatever needs to be said and nothing more needs to be said. I'm certainly not one of them. I believe that the purpose of scholarship is to keep a conversation going. So again, thanks for providing to the organizers and to the responses. Let me begin my response to these comments by reiterating a point made in the book on methodology. I do not buy into notions of exceptionalism or to the idea that the study of political phenomena in the global south demands a qualitatively different set of presuppositions and theories. The perspective is, of course, disputed. A number of disputed scholars, speaking on the distinctiveness of the Indian experience, argue strenuously that Western theories cannot possibly apply to the post-colonial world. Authenticity and indigenous social science are undeniably the flavor of the current intellectual season. The two most celebrated scholars in India are precisely people who made this kind of argument, Ashish Nandi and Partho Chatterjee. The proponents of indigenous social theory, of course, make a valid proposition, but they also miss out on a great deal. In today's world, the central problem for societies is that of realizing justice and institutionalizing democracy. We have a great deal to learn from each other on this count. On a lighter note, we in the post-colonial world can hardly duck theories that come to us in waves from Western universities and think tanks, of course aided by the global publishing industry. How is it then possible to do so? We have cut our academic teeth on these theories. Western philosophers and philosophies are part of the folklore of the Indian Academy. The other day I started looking at an ancient text which actually comes up in the epic of the Great War, the Mahabharata, and every staple of the social contract theory was there. And I just thought it's very strange. I studied in Delhi, I taught in Delhi University, and we start with Thomas Hobbes when it comes to social contract, or Locke. This is exactly what in the Shanti Parva I said, people live, and then of course there was acquisitiveness and greed. They ceased to obey the laws of justice, so you needed a king, and these are the duties of the king. And here we are with this text which has been translated and annotated, and nobody ever teaches that as part of. So that's a whole Western theory on the academy. Still, doubts about the capacity of liberal theories to negotiate a qualitatively different political context remain, and that is why I endeavored to do so. Take secession. The contrast between Quebec, Scotland and Catalonia on the one hand, and Kashmir, Baluchistan and Tamil Eelam on the other is striking. Can theories that take as the referral the judgment of the Canadian Supreme Court in Quebec adequately deal with the complexities of the Kashmir problem? That was at the back of my mind when I suggested that in context stamped by excessive violence, third-party intervention, mobilized minorities and illiberal leaderships of the separatist movement, even limited advocacy of the right to secede might well become even more hesitant. Alan Buchanan casts a skeptical eye on this argument. What is so specific about the Kashmir case? Aren't all secessions contested? Of course they are. A contestation is inbuilt into secession. A month ago, Crimea broke away from the Ukraine, beat by a referendum, and was incorporated into Russia. According to plebiscitary theory of secession, this particular case of procedural secession should have occasioned little controversy. The decision, however, took the Western world by storm, prompted hysterical predictions of another Cold War between an existing superpower and a resurgent one, and led to the imposition of sanctions on Russia. The secession of Crimea from Ukraine and incorporation of Russia was not contested by the parent country or by the country that the region joined, but it was certainly contested by the global community. Secession is a particularly difficult problem for political philosophy, points out Valentina Gentile, for it is difficult to accommodate international and domestic aspects in the same theory. Indeed, the point is well taken. Yet, in some cases, the duality does not pose a problem. When the parent state recognizes a breakaway state, the UN recognizes, otherwise it doesn't. I've already touched on this issue, so I will not repeat it. Now, the reason why secession, coming back to Buchanan's engagement, the laws that, let me step back a minute. The laws that regulate secession in international relations are the laws of war, and this poses a problem for normative theory. You know, where international relations is concerned, most of international theorists that are international relation, I was just at a meeting the other day on Nehru's non-alignment. They are still wedded to one smorgasbord. I have not seen the normative turn in international relations really touching realist philosophies. It is all about maximizing your territory, maximizing your security. I think international relations has paid a heavy price for seceding from the discipline of political science, because they really have lost their normative moorings, at least in our part of the world. But the laws that negotiate secession or attempted secession in the post-colonial world are also laws of war. The reason why secessions are so messy in the post-colonial world, for example, compared to Scotland or even Catalonia, from their parent country is fairly obvious. For countries that wrested independence from colonial powers in the second half of the 20th century, secession is a dramatic failure. Of the failure to consolidate the territory of the nation state. The nation state is highly overrated, and in our part of the world it's one of the major mistakes of history. Even so, in a global context that continues to hold the belief that the nation state is the only worthwhile form of political organization, post-colonial states simply cannot come to terms with loss of territory. Matters are worsened because in the international community, states that cannot hold their territory together are castigated as failed states, crisis states, fragile states, by other governments, donor rating agencies, and certainly by Western academics, for whom research on failed states has become a rather profitable industry. Any one of these dubious titles casts a particularly dark shadow on state capacity. It is not surprising that the response to criticism has been the acceleration of what is called nation building. There are a great many tragedies waiting to happen in South Asia because state-making was not preceded by nation-making, as is the case with Italy and France. We all know how Italy and France, we have made Italy, we have to make Italians, or that, when we want to make France, one language, one curricular conscription in the army should be the recipe. I mean, you look at India, which is such a very plural society, in the country, both sides to the conflict have invoked and harnessed hyper-nationalism to their project, and the country has been rent asunder by violence, by xenophobia, and by bigotry. This gentleman who everyone predicts will become the new Prime Minister of India, and in event we are resisting much against the laws of gravity, went to Kashmir the other day and said, lift Article 370. 370 is what the article in the Constitution that gives Kashmir autonomy. And immediately there was a flurry of response. Yes, of course, why should Kashmir be autonomous? Lift it. I cannot tell you the mass hysteria. A movie on Kashmir can actually prompt crowds to burn down movie halls. Nationalist anxieties about the eruption of subnationalism legitimize extreme violence on both sides. Paranoia over territory lost and dreams of territory regained sanctions the imposition of highly coercive legislation. The sad part is this legislation has accepted. Now, this is enough case to see secession as a prima facie right, that is a breaking of the constitutional pact. Now, Margaret Moore argues very rightly that the issue is not whether not whether secessionists have just cause to renege on political obligation to the state. The problem is grounded in a deeper, more fundamental analysis of whether people or the state have rights over territory. The idea of a plebiscite in contested secessions, argues Professor Moore, seems like a mechanism of conflict resolution and not a fundamental right that the people of Kashmir hold. Now, two responses are in order here. The first has to do with this very elusive concept called the people. We all know what Ivor Jennings said, somebody has to decide who the people are before they decide. On the other hand, somebody like Edmund Morgan says, look, this concept of the people has come to replace the divine rights theory. It's a legitimizing, instant legitimizing. Now, very often this whole issue of the people is sidestepped by talking of the people as a nation. But the problem with nations is that nations include and nations exclude. Consider that Pakistan was created as a homeland for the Muslim community of the subcontinent. Yet a country, a subsect of Islam, the 1 million strong Ahmadiyas, have been categorized as non-Muslim and as heretics because they believe in as a prophet that the rest of the Muslims. It's a complex issue. Interestingly, the headquarters of the Ahmadiyya community are in India. Clearly, the claim that nations have the right to their own state reproduces infinitely the minority problem. Then, how do you grant except an endless cycle of secessions, what has been called recursive sessions. Recursive secession. My second response to Moore's argument has to be empirical. There is no disagreement with the view that plebiscites should have been held. This was in keeping with the promise made by the government of India. But the issue was, it's actually a whole case of the internationalization of an issue and the laying down of certain conditions by the Security Council that the Pakistani army has to withdraw, that the Indian army will withdraw. Neither happened, so the plebiscite has never really been held. There's a more fundamental problem at stake here. In principle, it is not too late to hold a referendum, and we would talk about, many of us would say, hold a referendum, let us see which way, and I'm talking only of India-Pakistan. I consider it's actually the de facto line has become a de jure line. Let us have a plebiscite. However, a great deal of water has flown under the bridges of this spectacular river of Jhelum, of the even more spectacular valley of Kashmir. You have to understand how much Kashmir is a part of our collective imagination. When I was growing up, every romantic Bollywood film would have a song in Kashmir. When two people met, they immediately went to Kashmir to sing a song, they came back. Then when they got married, they went to Kashmir for their honeymoon and they came back. So all the nasty things happen in the rest of India. Kashmir was a land of romance, and we all grew up in these, everyone dreaming of a honeymoon in Kashmir. So it's very much in our imagination as the paradise, which I said one of the past Mughal. If there is a paradise on earth, this is here, this is here, this is here. In 1989, but there is a problem. In 1989, the uprising on the valley was centered on the demand for azadi, freedom, which can be interpreted as I have said. By the mid-1990s, the struggle had been hijacked. Now, the entry of third parties into a conflict situation catapults to the forefront a famous question asked by Plutarch about the ship of Theseus. If the wooden planks of an old ship, asked Plutarch, are replaced over a period of time in order to restore the ship, is the ship the same or a different one? And Hobbes asked another question of the same phenomena. If the original planks of the ship are not discarded but used to build another ship, which is the original ship of Theseus? Witness the paradox. As concerned citizens of India, we have the moral obligation to express solidarity with fellow citizens who have been subjected to institutionalized injustice. Do we hold the same obligation when an entirely new set of agents come into the area? And these are mercenaries. From outside the boundaries of the state, rework the litany of grievances and assert the right to an independent state that will have room only for the believers. The valley has been subjected to ethnic cleansing, including moderate Muslims. It's not only Hindus and Sikhs that have been asked to move. The original ship of Theseus has been remodeled. It is simply not the same ship. What do we have a plebiscite on? I mean, we have to face these issues. I mean, you have to face issues that the entry of violent actors, the violence of the state rules out a plebiscite. It would not be a fair plebiscite. Empirical evidence forestalls the taking of empirical stand. We come to the question of minority rights. And I've already talked about minorities who have mobilized, but I mean, I asked one of the leaders, what are you planning to do with minorities who don't want to go with you, with the Sunni majority in the valley? He said, partition the state. I said, partition the state? He said, yes. Haven't you learned from the partition of 1947? You know, partition, Ladakh can go, Kargil can go, Jammu can go. It's what about the people in the heartland of the valley, the tribal community, the nomadic community that don't want to be a part of an independent state? So that is the kind of answer we are getting, which actually, I'll come to the two final points. First is the clash of rights, the right to secede and the right not to secede. Now, what do we as Democrats do? Do we trump one set of rights over another, or do we look for some kind of, let me give a small example. How much time do I have? 5 minutes, okay. You see, this issue comes up very strongly first, in my mind at least, in the case of a very gigantic irrigation project that displaced thousands of tribals in the western part of India to build a very gigantic dam that carried the waters of the great Narmada River from the south of Gujarat to the northern desert areas. Now there was a great upheaval about the rights of these tribals not to be displaced because they are they're forest communities. They've lived, I were interviewing them and they said, we miss the forest, we miss the freedom of the water. We also miss changing our husbands because these are matrilineal communities. They have multiple husbands. So they said, we've been resettled in puritanical Gujarat where neither drinking nor smoking is allowed, and we certainly can't change our husbands. I was very envious, I can tell you, about this kind of attitude these women had towards men, purely instrumental. The point, there was a clash, there was a problem with cultural dislocation and cultural upheaval. At the same time, if the water had not reached those desert areas, there were these starving peasants who were waiting for waters for decades. What do? You don't build the dam and you consign these peasants in the desert areas to eternal penury, or you build the dam and dislocate people. So it seems to me the only sane model to follow, and that was the rationale of many of us who were fighting the dam. We were not saying no dam, we were saying lower the height of the dam, it displaces few people, have very effective resettlement rehabilitation policy, but reach water to those peasants. When you come to a clash of rights, you can't say this right will supersede another right. What you do is to lower the scale of the good that both parties are asserting competing rights to. And that is what I have suggested when I talk about self-determination, solid self-determination, return Kashmir to what the Indian government had promised. This brings me to the point raised by Valentina Gentile. These theories do not allow us to negotiate the problems of the real world, particularly the problem between individual rights and group rights. Now, I have argued, and I reiterate it here, that I don't want to take more time, that collective rights, I come from a country where people have been killed because of their identity. So the first thing is to protect the identity. You are killed because you're a Muslim, or you're a Hindu, or you're a Sikh. Right? So the idea is to protect minority identities, to see that obviously the life of an individual member of that community is dependent on the community. But that doesn't mean the right of the community to exist will violate the rights of the individual. So I have argued in another work that if you talk about equality as a foundational principle of secularism, which promises equality between groups, then the same principle should apply to groups within groups or individuals between groups. I don't think I shall go into the details. Okay, finally, the other substantive question that Margaret Moore raises has to do with the way I conceptualize democracy. Whereas she conceives of democracy as a way of guaranteeing equal political voice by the governed about the way they are governed, and who governs them, I conceptualize democracy in a looser way. I do not think Moore and I differ greatly about the way we conceptualize what a good political society will look like. She would rather see different values emanating from different principles. On the other hand, I see these values as emanating from the basic principle of democracy, for one basic reason. I may be wrong, but I can think of few works that have worked out the relationship between democracy and justice. In fact, that volume edited by Carol Bateman and somebody else, I don't remember the co-authors, in honor of Brian Barry, said very specifically that no sustained attempt has been made to join democracy and justice. Now this is worrisome when you consider that justice is not only a provenance of democracy. Justice can exist in non-democratic society. Every tyrant claims to be just. So in a way, justice, suppose we were to then work through the presuppositions of democracy, that of equal political voice, which is Margaret Moore's own preferred choice. In order for people to have equal political voice, surely the state or some institution should be charged with the responsibility of neutralizing background inequalities, because you cannot have equal political voice if you have entrenched social and economic inequalities. Now, these are not siblings, they're not first cousins, they're constitutive of democracy, itself. The main problem with privileging different values is the outcome of different principles that are in the process, concepts tend to stand in for each other. And one example that readily comes to mind is how redistributive justice has come to stand in for equality. The entire liberal debate is not about equality after John Rawls. It is about redistributive justice. So redistributive justice is not a synonym for equality. It is a precondition for equality. Right? Equality is much more than redistribution of resources. It is about the equal standing that people have in relation to each other. Now, when you substitute redistributive justice, and tomes have been written on redistributive justice, you actually land up with a sufficientarian position. A sufficientarianism is not about equality as a relational idea. Sufficientarianism, Frankfurt, for instance, would say, how does it matter, people are unequal, give them enough to eat. That doesn't really wipe out the fact that if people are poor, they're not only poor, they're unequal. Now, that striving, that aspiration towards equality has to be the focus of political philosophy. But the problem is that very quickly concepts come to stand in for each other, but that is something I have been my bonnet about, so I'll just shut up at this moment. Alan, I don't say secession is like divorce. I'm sorry, you misread me there. I said it is like euthanasia. I think I will end here. Thank you again very much for your wonderful comments.
Okay, thank you, Neera. Now, we have almost half an hour for questions and answers. We have distinguished scholars in the audience and very passionate students, so I will hope many questions. The only thing I would like to ask you is if it's possible to come at the microphones in order to have our video intact. Okay. So, who's the first? Could you possibly, sorry. Thank you very much.
I'm kind of intrigued by switch this on.
On the boss side.
Why don't you speak from here?
Yes, sure.
It's the physical.
Yeah, that sounds good. It's a very simple question, in fact. I'm kind of intrigued by how Margaret would reply to Neera's replies, as it were. So there's this question about people having jurisdictional authority, which seems to be doing a lot of work in the way you're thinking. And then the question was posed, who exactly are the people here, right? And it made me think of two examples. In Northern Ireland, which is another contested issue, right? So you have the birth rate of the Catholics that it's higher than the birth rate of the Protestants. So depending on when you ask the people, you would get a different outcome. So there's an argument that the Catholics are waiting for the moment, which is actually coming up, when they would have a numerical majority. So there's a temporal issue with defining the people. And then there's also a geographical issue with defining the people. So in the case of Scotland, yes, there's a referendum coming up, but there's been a question, who should vote in the referendum? Should it be just the Scottish people? Should it be the rest of the United Kingdom? Depending on who you ask. So both on temporal grounds and geographical grounds, the concept of people obviously changes dramatically. And rightly, you were saying, who are the people exactly? So I was just wondering if Margaret could respond.
that's a kind of challenging question, but my thought was, so I didn't have, so,
Okay. Go ahead.
So, in my comment, I didn't work out how to institutionalize that. I mean, so your response, a good response is it would be very difficult to institutionalize a referendum. So I think there's a difference between a moral principle or a justificatory argument and then how to institutionalize it. And so there's a good question, but and you would and I think that a lot of work needs to be done on exactly how to institutionalize it, right? Although I should comment that Northern Ireland's actually quite a good case for my argument, as it has achieved relative peace, right? No killing. So, but I guess what I was interested in is the idea that we have that I just thought that there was an opportunity here to talk about how we should think about territory. Because in the past, prior to democracy, we thought of it as something like property, right? That people could just take with them, right? So sovereigns could take territory into marriage as if it was property. And in a democratic era, I don't think we can have this view anymore, that we have a different view of the rights of people and the relationship of people who are equal in a democratic way and the land that they have. And they can't be shunted around this way. So we need an account. And we've done very little thinking about it. So I think that this is one of those cases where we're starting to think about how we should think, how we should have an international law or an international regime where we have a consensus about that would procedurally institutionalize a different understanding of the relationship of people to territory. And the case of Kashmir, I think, originated in an international order where imperial authorities had no difficulty partitioning land and moving people and shifting political orders without regard for people. And then the results, I think, have been catastrophic. And so we still have to think through, I think, that argument because it doesn't go away. So so my response is simply that I think there's an opportunity here, and it's raised in that case. And I'm not saying that, actually, maybe that sounded very critical because I'm not saying that Neera's fell short because actually nobody has done it, okay? But I think that needs to be done. And actually, in the case of Scotland and Northern Ireland, there is a kind of idea that the people, however, there's different conceptualizations of that, but the usual, one standard one is the political unit defines the people. And then you also have ideas about politically mobilized relationships. I don't have a cultural view, right? But there are definitions in place, and there are accounts of collective agencies that we can draw on. But it certainly needs to have more of a conversation and be brought into the account of contested territory.
Would you like to answer to this one?
Well, I think part of the problem is that the United Nations in 1945 had decided very specifically the right of self-determination shall be given to a people, and the people were strictly within the colonial context. Jammu and Kashmir is not within the colonial context, so that I think was a real problem when it came. Colonial context separated from the metropolitan power by the salt water principle. Once a country had got independence, no further breakaways were to be allowed. So therefore, the immense investment in military repression in Congo and Biafra. I don't know, maybe Alan would have something to add to this.
Well, I think there was an attempt in the interwar period, during the League of Nations period, to try to do something in international law to give some closer connection between the people and the political unit by having plebiscites in some areas of the disintegrating empires that were lost in World War I. But it was generally thought to be a disaster. And when it came to decolonization, no one had any confidence in the idea of sorting out the peoples that were within the boundaries of the colonial states, and instead they relied on the principle of Oedipus Sudetus, which had actually been developed in the Latin American decolonization from Spain 100 years earlier. And they just said, we can't deal with the problem that the gentleman rose over here about who's the people. We can't deal with it. We're just going to take the existing boundaries of the colonial states, and that's where the right of self-determination is going to be exercised. And we're living right now with their failure to cope with that problem. But we shouldn't be too hard on them, because there had been a kind of limited attempt during the League of Nations period. And there are a lot of different opinions about the League of Nations, but I think there's considerable consensus that part of it was a huge failure. So I think it is, I think that Margaret's right. You need to first try to think through, in a sort of an ideal theory way, what's the proper way to think of the relationship between these three terms: the state, meaning some sort of relatively stable structure of institutions, the people, and the territory. But when it comes to then trying to decide what you do with that practically, there are a huge number of constraints that are supplied by two things. One, the fact that we just have a very statist system internationally, and the other, just the tremendous asymmetry of power of the system.
Well, Neera, thank you for writing this book. I haven't read it, but I'm not a scholar or a student here. I'm a political activist from Kashmir, so my question will be more practical. I think it's on.
Yeah.
I can, okay. The question is, what about the part which is under administration of Pakistan? And secondly, instead of supporting or not supporting a plebiscite or a referendum, why not support first the integration of the two different Kashmirs and the integration of the two, or the many different thoughts in Kashmir of different religious backgrounds? I think we as Kashmiris honestly have a right of secession, but we do not know what we want. We are so much disintegrated because of the line of actual control in Kashmir, and because of the heavy army presence on both sides. So maybe we Kashmiris need a lot of time to think and revisit our own strategies and talk to each other what we actually want, because an independent valley only will not survive. We need the places like Jammu, like Ladakh, or even Gilgit-Baltistan and Pakistani administrated Kashmir, which are very resourceful in water. So my question is, what about the other parts of Kashmir, and will we Kashmiris get an opportunity to form a strategy for secession? That's it.
Okay, this is tricky. So would the suggestion be that you cannot secede unless the three parts of Kashmir, Jammu and Kashmir come together?
Well, we don't know for what to secede. What is the valley alone? I don't know which political leader you talk to, then we will have a partition. But Kashmir has never been religious, and it cannot be separated on the basis of religion. It has always been a multi-religious, multicultural entity, and even the Mughals were very stunned by the kind of Islam which was practiced there. So the question is, first, that we are very much divided, not only in the Indian part of Kashmir, but also in the Pakistani part of Kashmir. So we have never had a chance to actually discover and know what we actually want. And isn't that a better or a more practical option first to give the Kashmiris a chance by maybe freezing the issue, or and while opening the borders and let people talk to each other, because we don't, in the dialogue, we don't know what people of Jammu want, and we certainly don't know what the people in Pakistan want.
Tassin, you had something to say?
The order, Alan, you have? No, okay. Let's follow the order. The order is Daniele.
Thank you.
I appreciate that. I'm not going to respond to your question. I appreciate it very much your remark. And it's very unlikely. It's very unlikely that somebody, it's very unlikely that somebody coming from a contested area comes to the fore and say, I don't know what to do. Because what is generally happened when you go to Northern Ireland, to Kashmir, to Bosnia and so on, you meet only, at least I've met only people with very strong views. And so I very much appreciated your comment. And I hope very much that more people like you will be around. Because if more people like you will be around, possibly self-determination conflicts will be less controversial, you know? But that's, I mean, actually, you know, I didn't want to comment about you, on you, but I really appreciate it.
It really is. Yes. It's a seeing point of view.
Yeah. I really appreciate it, you know? I mean, you're right, it doesn't work.
No, I think.
Good. At least one word. No, I mean, I think the general discourse on secession, and I look at Buchanan, because you were one of the first to put the issue into the center of political theory, I've always been a bit unhappy, because it was never clear to me what secession was the answer to which problem. You know? I mean, somehow we can say it's self-evident. But if we single out the issue and we try to respond, to say what the secession is giving an answer to, we can have a long list of different issues. One issue is respect of human rights. What, to put in your own language, the remedy to institutional injustice. That's fine. So are we sure that after secession we get more human rights respected? Give me an answer. Give me a case. Is now Kosovo human rights more respected now that Kosovo is more independent than it used to be? Doesn't seem so, and so on. Is an answer to self-determination? It depends. It depends from your own community, and in the majority of cases, the minority of the new state is more oppressed than the minority in the old state. And we have seen too many cases of oppressed minorities which have become oppressing majorities. And therefore, you know, it's not an answer to that. It's an answer to the fact that people would like to live together, and then we manage to build better communities which are happily living together because they share common values. Religion, of course, is a typical case. Language is a typical case. Other forms of identity, that again is not the case. So at the end of the day, it's not clear to me if secession is an answer to what. And if we list out some of the typical issues for which secession is advocated, we found out that the remedy is worse than the sickness. And therefore, you know, I start to be a bit skeptical about that. Not because I'm skeptical about secessions, because I don't see what's the solution. So I mean, we are now discussing about Kashmir, then we will discuss about Ukraine and so on, and each of us are Vittorio speaking about Northern Ireland and so on. But I mean, I would like to urge you on one simple issue. Since you have been critical about international relation theory, that's fine. But since you come from the political philosophy perspective, I would hope whatever you would call yourself, you should have discipline at least, and since political theory is mostly normative, I would like to ask, what is for you the solution to the Kashmir case? Because at the end of the day, we need a solution. I mean, political theory is normative. We have heard from a colleague, as I said, I have no clue. But now, have you got a peace plan for Kashmir, and how will you operationalize it? And of course, do you have any idea that if the plan will ever be implemented, the outcome would be any better than the current situation?
I wish I was one of those policy people who has grand plans for Kashmir. I think two things immediately need to be done by the Indian government. You have to restore the regional autonomy that Jammu and Kashmir possess constitutionally. That is one. Secondly, you have to lift the army presence and all coercive laws and allow people civil liberties. And then we ought to leave it to the people of Jammu and Kashmir to decide what they want to do. No, it will not be better. I can guarantee you that. For the simple reason that the issue has become so polarized within the state, which is multi-religious, Buddhists and Hindus and animists and Sunni Muslims and Shia Muslims, each wanting to go their own different way. It will not be. But let it come from them. Let them try. I think let it come from them. I think a sane, a prudent solution would be, tell us what you want to do. We give you autonomy. We can only persuade, you can't lay down. You can only persuade that, it's far better living in a multicultural society, I don't normally use multicultural for societies, like in a plural society, amongst different languages, different ways of belief, different gods, different music, because you realize that there's so much in common. We go to Pakistan and we find we're the same society. We worship God in the same way. We have the same music, the same folk tradition. There is no difference between Tahsin and me in terms of our facial features. We look like cousins. So I can't for the life of me figure out what separate states have done to people or for people. It's just seen as a panacea for every evil that you have. I think Alan has put it very well. The secessionist is convinced that every problem he has is due to the state, and all these problems will be solved once he has a new state of his own. So I share all your misgivings. That is why, and believe me, in India I was told you speak from the Hindi heartland as a Hindu nationalist. I said, will you please shut up? I said, nothing of the kind. Why can't you advocate secession? I said, who are we going to hand over power to? So it's too much of a mess. I don't have any roadmap. No, I wish I did.
I'm so glad that Daniela brought this up and that Neera made this reference to a passage in my 1991 book. I think generally the drive for secession signals a kind of failure of imagination. As you said, we get a terrible problem where they're saying, let's create a new state, right? I mean, it's often, you often do replicate this. Donald Horowitz in his book on conflict shows that often in cases when you get a secession, you get a replication. It's just different people persecuting different people. Not always, but in some cases. And that's why I keep coming back to this idea that the first resort ought to be, well, the first resort ought to be respecting people's individual human rights. The second resort ought to be some kind of autonomy within the state. And in the case of what Neera said about the plebiscite, you said, you know, how can you have a plebiscite when you've got these foreign fighters coming in and all this violence? Also, how can you have a plebiscite when you've got the Indian Army there oppressing people? And it seems to me the only possibility for a plebiscite that would mean anything, and perhaps the plebiscite should be in the entire area, as you were suggesting, would be if there were some international or regional peacekeeping force that were adequately resourced and willing to stay there long enough to create some relatively stable conditions in which people could talk to each other across the different parts. All the Kashmiris could talk to each other. And then at some point, perhaps the situation would be stable enough that they'd be in a position to formulate a referendum question. Even formulating the referendum question is no minor matter, right? I mean, in the case of Crimea, I think there was a huge mistake, right? I mean, I think there actually was some valid case for having a referendum in Crimea, but I think it should have included 3 options, not 2. Not just, do you want to be in Russia, do you want to stay in Ukraine, but do you want to be more autonomous in Ukraine? That would have been, or do you want to be more autonomous in Ukraine and everybody have dual citizenship in Russia who wants it? I mean, there are lots of different kinds of alternatives, right? But the first thing is to create a kind of relatively peaceful, stable space in which people can be free to discuss and to be moving toward the possibility of a plebiscite. But I think that's going to require a commitment and an investment from some third party, some international institutions. And, you know, the worry is that it will turn out like Cyprus, that it will turn out to be a 60-year commitment rather than, you know, the projected 5-year commitment until you get a plebiscite. But that's, I mean, I'm so reluctant to make any practical suggestion about this because Neera's convinced me that this is the case from hell. This is the most, you know, one of the most difficult cases. But if I were forced to try to say something, that's what I would say. Something along those lines.
Yeah, just really quickly. I just wanted to clarify about the plebiscite. I didn't actually say I was for a plebiscite. I didn't actually say I was for a plebiscite. I said that the requirement of a plebiscite invoked a different theory of territory, right? So you wouldn't, and there's all kinds of problems with plebiscites. I mean, there are various problems that Victoria mentioned, but also the problem that it's very static, right? It doesn't have so you have a plebiscite which gives you an answer, but there's no real form for negotiation, right? And because often it's a strategic plebiscite, right? So the group makes a plebiscite because what they want is negotiating power. But then, having got this negotiating power, it kind of escalates out of control, right? So, I mean, there's a really strong case for, in some way, having people decide. But they can't, but it doesn't follow that the way that people decide is in some one-off plebiscite with it. Because it's a very complex question, and you would want to build relations and political and forms of autonomy that reflect the very different kinds of aspirations of people, which are shared usually with the host state, with an adjacent state, and with the people in the community. But
there could be stages, right?
And there would be stages. So the idea that the people decide doesn't necessarily mean, oh, now you need a plebiscite, because I think that is such, that's an institutionally crude mechanism, and I think that there's reasons why it's a failed mechanism.
Not just a one-off plebiscite.
Not just a one-off plebiscite.
Okay. So we have time for 2 quick questions. Sorry, 2 quick questions, or we would like to collect. So Kumar first, and then
ask them first.
okay, no, it works. Yeah.
my question was basically about like we've been talking about like the concept of the people, like who are these people who can actually decide about territorial rights or like the right to secede. But in the terms of at least like thinking about Kashmir, like do we also think, and this is like problematic, but also like do we also think that the people of like the whole of India also should have something to say about this, not in the sense of like deciding whether Kashmiris should secede or not. Obviously that question belongs to them, because like this thing about it has so much polarized the mainstream discourse that it is a non-starter. There is no conversation. Like if Arundhati talks about secession, like, or if she talks about self-determination, then we talk about like, you know, we bring about old Victorian laws about, oh no, you know, we don't talk about Kashmir. Like there is no question about, so it polarizes even the discourse within a country. And so there is no, so the political will to even talk about these kind of issues never begins. So so no political parties in the sense has any kind of interest in engaging in any form of discussion. So in a sense, when we talk about this, do we also talk about like there has to be a discussion at the larger level, because it somehow seems that there is whole concept of territoriality involved in the sense of people living in India about what they imagine about Kashmir to be, and so a lot of discussion never moves forward because we cannot even think beyond that, you know, like Kashmir can be an independent part, or like Kashmiris have their own right to decide about what they want to do about themselves. So in that sense, I think this concept of people needs to be like even more complicated. I think, I don't know, similar when Professor Buchanan was mentioning about like Catalonia, like, you know, I don't know, is it the same problem there? Why doesn't the Spanish government want this conversation to begin? Is it like the problem of like so in the Indian context, it at least seems that is the case, whether it be of Kashmir or in the northeastern parts, like different states talking about secession or self-determination. So I think, yeah, so I think the concept of territoriality is about the people who also want to secede, but also in the minds of those who do not want them to secede. So because they also imagine a certain form of territoriality in mind. So I think, yeah, just that was, thank you.
He made it work, yeah.
Brilliant. If I may bring back the discussion to Europe, because that's my background in European studies. And it seems to me that taking things from a European perspective might maybe have some illuminating consequence on the discussion on parties. You know, how many parties are involved in secession? Is it just two? Is it more? And my thought were in particular in matters of identity and the presence of Europe as an identity, which makes maybe the European case is different insofar as we have not only multi-level governance, which is also the case in India, but maybe a sort of further identity that allows the region that wants secession or the state that wants secession to sort of overcome the nation, because you were mentioning how difficult it is to overcome the nation, not only methodologically speaking, as Ulrich Beck has been saying for ages, but also just in terms of, you know, who we are and who, against whom the secession states fight. So I was wondering whether you can share any thoughts on the role of Europe in justifying or maybe you know, making it less controversial for certain regions to go for secession as a sort of as I said, allows one to overcome the level of the nation and go beyond, and in a sense feel less that they're rebelling and more that they're joining a bigger family. And I suppose that the same question could be asked in terms of Ukraine, although from a completely different perspective of what's the role of Europe in that sort of secession.
Okay, yeah, again will be for the next session. Neera, if you want to conclude this.
Well, just one thing about the European case. I mean, in some ways you might think that the fact that Spain is in the European Union and as the UK is, that it should make it easier for secession, because secession shouldn't make such a big difference to many of the social, cultural, and economic relationships. You're still a European, you're still in the European Union. But although the UK is not in any way suggesting that they would prevent an independent Scotland from coming into the European Union, just the opposite in the case of Spain. Spain is saying that it will under no circumstances allow an independent Catalonia to become a member of the European Union. So I think that there's a potential that secession could be less traumatic and could, in a sense, mean less in the European Union because being a state means less, right? Independent statehood means less. But in the case of Spain, they're reasserting the primacy of Spanish identity understood as involving a unitary state. And they're willing to wreck the European Union if necessary in order to keep Catalonia from seceding.
Okay, Neera, would you like to add something?
I thought the Spanish socialist prime minister, I forget his name, in Spain, had said that Catalonia would be...
What you mean, the previous?
Yes, the previous. Yes, that they will be allowed to join the European Union as independent groups. They will have a representation. They will have representation in the European Union.
The current Spanish government vehemently